Thank you so much, Charles, and thanks so much to you and Pierre for your kind invitation to participate in this great project. I do feel honored to be part of this group of distinguished scholars. As honored as I feel to enjoy this privilege, it is a somewhat dubious honor still because the topic that I'm asked to cover is quite tricky, or it is so at least to me. So you see, ladies and gentlemen, dear colleagues, when Pierre and Charles first approached me in order to ask whether I wanted to join this project, the tentative title they suggested was Protection Against Public Authorities' Censorship. And so when we were discussing on how to address the issue thus framed, I naturally interjected, well, that's basically free speech in Europe, is it? And evidently, free speech in Europe is a topic that is hardly to be covered in a single chapter. After all, that's what the volume, as I understand it, is about. And hence the slightly adapted title of my talk here today. It may be a bit playful to the taste of some of you, but then again, Charles and Pierre were okay with it, and who am I to judge in the end? The title, of course, shamelessly borrows from Milton's 17th century pamphlet Areopagitica, a speech, as it was subtitled, for the liberty of unlicensed printing. Perhaps alongside Mill's On Liberty, the most powerful defense of free speech ever published in Europe. The lack of shame in borrowing the title should however, not be overstated. After all, Milton himself had borrowed it from the Greek philosopher Isocrates, and both Isocrates and Milton, of course, allude to the same object, the Areopagus, the famed rock in Athens in the northwest of the Acropolis, which in classical times served as the location of a court of justice, and before that was the seat of the Council of Elders, a place, we may say, thus emblematizing the political sphere. It was this emblematic understanding that Milton used in drafting his speech for the liberty of unlicensed printing. A speech, of course, that made a powerful argument for truth to prevail in an open exchange of viewpoints. An open exchange which alone would provide the proper foundation for the political sphere symbolized by the Areopagus today, as it did in the times of Milton and Isocrates. Let her and falsehood grapple, Milton famously argued. Whoever knew truth put to the worse in a free and open encounter, which is why Milton strongly advocated against the stop of truth by hindering and cropping the discovery that might be yet further made, both in religious and civil wisdom, or so he put it. Observe already at this point, and that's of some importance here, that Milton's argument is not about factual truth, as discussed in this seminar last time around. What he advances, or to be more precise, what his argument entails is more than just a safeguard in favor of factual accuracy. It is an invitation to think about the pursuit of truth in the interrelation of liberty and license, if you will, against the backdrop of free speech, and it thus goes beyond the mere liberty of unlicensed printing. Still, this liberty may well serve as a proper point of departure when it comes to our quest for truth, which as a quest for informed political discourse and the means necessary to pursue it serves as the backbone of any society deemed to be democratic in more than one meaning of the word. Now, nowhere it seems this is depicted in greater clarity than in Article 10 of the ECHR, a provision that we may understand as the culmination of our common European understanding of the value inherent to free speech and the necessity to protect it. Section 2 of said article, as you all know, of course, states that the exercise of the freedom safeguarded in this section may be subjected to such formalities, conditions, restrictions, and this, however, doesn't move forward here. Ah, yeah, now it does. Formalities, conditions, restrictions, or penalties as are prescribed by law and are necessary in a democratic society. We all know, of course, how this limitation clause works, and there is no need, I think, at this point, to give a deeper introduction at this in front of a group of experts. Just as there is no need to emphasize that we find here. The core mechanism of what Charles and Pierre may have had in mind when approaching me with the topic of protection against public authorities' censorship. What we need to discuss, however, in a first step is the character of these formalities, conditions, and penalties. Public authorities are to engage in only subject to the requirements stated in Section 2. If, in order to do that, we were to turn to the guide on Article 10 ECHR issued by the court, we would find ourselves referred to a large variety of different measures, such as a criminal conviction alongside a fine or imprisonment, an order to pay damages, even where these damages are symbolic, a conviction, even where execution is suspended, the mere fact of having been investigated in criminal proceedings, the confiscation of a publication, seizure by the prison administration of newspapers sent to an applicant, a refusal to grant a broadcasting frequency, a judicial decision preventing a person from receiving transmission from telecommunications satellites, a ban on advertisement, a disciplinary penalty imposed on a doctor, an order to disclose journalistic sources, even if it's not enforced, the refusal to grant authorization to film inside prison, the refusal to grant access to a reception center for asylum seekers, the arrest and detention of protesters, and so on and so forth. Now, even if we were to take this as, let's say, modes of state interference, these incidents listed here, on the one hand, are of course far from exhaustive. On the other, they are highly unsystematic, if not to say arbitrary, and thus, of course, by themselves are not in a position to be used in an academic endeavor such as the one pursued by Charles and Pierre. So what my chapter will intend to do is bring some order into this chaos and add some various instances from national high courts that may give a fuller picture of the issues at stake, in particular as to questions of what Luciano Floridi referred to as the fourth revolution that seems so far not have to enter into the guide on Article 10 ECHR when it comes to government's interference, at least. Albeit this is an important task, it is not something that will work, I think, very well on its own, because in order to complete this task, one has to address an issue of prior, if not outright, I think, of prime importance. And that is what I would like to talk about today. What is it that public authorities must not, or must only for very strong reasons, interfere with? Or to put it more bluntly, what is it we speak about when we speak about speech, such as in free speech? After all, it is the exercise of the freedom safeguarded in Section 1 of Article 10 that must not be unduly restricted by way of formalities, conditions, restrictions, and penalties. Now, you will say, and I see the skeptical look on Charles's face now before me, that this is an odd question, because evidently Article 10 ECHR protects information and opinions. After all, it was Marco and Oreste who talked about that last week at length. And so they did, and so they did most instructively. And in doing so, they covered a lot of ground concerning Milton's quest for truth. Question remains, however, whether the dichotomy of information and opinions is either exhaustive uh, and thus a dichotomy proper, and based on that, whether it is in any relevant sense self-explanatory. Today, I will argue that it is neither. For you see, since factual communication, information, if you will, and value judgment, opinions, if you will, are propositionally related to events in the objective external world, the qualification of the conceptual pair as dichotomous, and in this dichotomy as comprehensive, can at best appear adequate in precisely this reference. Opposing poles that would span across the entire subject of free expression are not to be found here. Rather, it is evident that the pairing reference to reality does not do justice to the multitude of phenomena that, if one considers only the widely branched group of artistic expression, already enjoyed protection of the safeguard of free expression according to common textbook knowledge. Poetry, for example, to quote Jeremy Bentham, has no very direct tendency to produce either correctness of knowledge or rectitude of judgment. Of course, scholarship at times goes quite some length to display the doctrinal constructions that would be required in order to insert acts such as the initiation of prostitution or appeals to the solidarity and financial helpfulness of others, which are recognized as protected by the safeguard of freedom of expression into a scheme of information and opinions. But let's be honest, this appears somewhat desperate. Nearly as desperate, I would say, at times, such as the ECTHR's assessment, according to which those who create, perform, distribute, or exhibit works of art contribute to the exchange of ideas and opinions. That is, unless we commit to a search of truth in a sense as comprehensive as the one employed by Milton. Fairly reductionist views of free expression omit, I think, and it's important to emphasize that, what is supposedly self-evident, that freedom of expression, as phrased in Article 10 ECHR and in comparable safeguards all over Europe and beyond, evidently is open to all conceivable forms of meaning. Beyond the categories, thus, of factual assertion, information, and value judgment, opinions, which against the backdrop of their propositional reference to reality reveal far more common than divisive aspects, freedom of expression wants to guarantee open communication processes in all areas of society, and thus guarantees the freedom of the individual to communicate. Free expression, one can state, if we would like to avoid further redundancies at this point, is liberty to communicate. That is the guarantee of a comprehensive freedom of individual communication. And as a first step, we should add with Joseph Raz, communication is to be understood broadly to include much more than the communication of propositional information. That is, it is much more than describing or evaluating events of the objective external world. This, of course, raises an important question when it comes to liberty and license, as alluded to in the subtitle of today's presentation. After all, what kind of liberty is protected and how much license is included in what we regard as freedom of expression? You see, Thomas Scanlon made this point with the greatest clarity. Such a comprehensive freedom of individual communication is an extremely broad class. In addition to and I may quote Scanlon here, many acts of speech and publication. It includes displays of symbols, failures to display them, demonstrations, many musical performances, and of course, some bombings, assassinations, and self-immolations. Um, the question of whether and to what extent and on the basis of which considerations such and other activities are to be excluded in or excluded from the protection of free expression as the foundation of our Areopagus are in the center of my thoughts today. Um, with the insight that freedom of expression protects communication as a whole, and Scanlon's remarks made this sufficiently clear. Well, further questions are inevitably connected. And evidently, the question first arises as to which factors are to be used to determine the relevance of communicative acts for our purposes and for the purposes of government interference and undue restriction. What is it, we may ask, that is to be understood by communication in the relevant sense here? Because evidently, as Fred Schauer emphasizes, a right to free speech does not contain a right to commit murder, to drive a car in a pedestrian zone, or to sell heroin. Um, uh, the funny question is why, actually, but we will get to that eventually. Um, Accordingly, it is not immediately obvious that the aforementioned bombings, assassinations, and self-immolations can claim the protection of free speech at all. Or, to put it differently, are deserving of being protected against the censorship of public authorities. Of course, if we first look at those acts that are almost taken for granted as communicative, it seems initially, I think, superfluous to make such a fuss about these things at all. Maybe obvious that a letter to the editor published in a daily newspaper is a suitable means of expressing the author's concerns. For example, if the writer was to critically question the agenda of a certain politician. But how is it to be judged if someone, instead of writing a letter to the editor, throws a pie at the same politician during a television interview? Is Monty Python's silly walk expression that is protected from state interference? And does booking a table at a Viennese cafe, or a cafe in Paris, if you will, or in Lyon, uh, uh, is that a statement that would imply a favor of Lyonnais coffee house culture that would be covered by freedom of expression? If we were to look at ECHR scholarship, when it comes to this, what we would have to focus on in this regard, or so scholarship would tell us, are the forms of action that are relevant in the question or for the question at hand. The wording, and Marco and Oreste have pointed that out, I think, last time, of free speech clauses, be it Article 10 ECHR, be it overall free speech clauses in Europe and beyond, is no great help here. Article 10 alone, I think, has almost incalculable number of decisions that impressively testify as to the multitude of phenomena that are within the scope of free expression. Think about films, computer games, works of visual art, posters, caricatures, photo burning, public nudity, wearing a badge, a flower, a uniform, hanging dirty laundry not far from Parliament, scaring away fish, holding a hunger strike, collecting signatures, shouting tally-ho, deliberately walking slowly, pouring paint on a monument, removing pieces of ribbon from wreaths. These and countless other examples are recognized as means of free expression in the case law of the ECHR, pardon me. And of course, The fact that Article 10 ECHR entitles a person to use any conceivable means of understanding of his or her own choice is clearly reflected in the case law as well. As the court explicitly states, the form of the expression is also to be regarded as covered by the protection awarded by Article 10, which protects not only the substance of the ideas and information expressed, but also the form in which they are conveyed. You may have come across statements like this in the past, evidently. And the form, in turn, as already indicated, is not further defined in the wording of clauses such as Article 10, or at least typically, or at least not exhaustively defined in provisions such as Article 10. ECHR. Article 10 specifically does not distinguish between various forms of expression. Thus, of course, all means of expression are included in the ambit of Article 10 of the Convention. Well, now, not to give undue preference to, let's say, linguistic modes of communication makes sense on various levels, of course. After all communication has some relation with some course of conduct, not only because the linguistic communication process is to a large extent shaped by extra linguistic elements, but not least because speaking, if you will, for example, is itself a bodily act. And now it becomes somewhat interesting because as Louis Henkin once remarked, speech is conduct and actions speak, and there is nothing intrinsically sacred about wagging the tongue or wielding a pen. There is nothing intrinsically more sacred, Henkin would write, about words than other symbols. And this brings us to an important point. All expression necessarily requires the use of symbols. Well, human language may be the most highly developed of all forms of symbolism. And on the basis of this, in the general view, as Edward Sapir has, among others, prominently emphasized, the normal type of communication of ideas is something that would derive from human language. However, that it does not necessarily distinguish it from other forms of symbolic communication. Which would mean that any conduct, of course, can be communicative. The question remains whether that at least leaves us with a, say, presumption in favor of language as the normal type of communication of ideas, assuming that the basic functionality of language is communication. Linguistic utterances would then be assumed to communicate with the help of other means. Well, other acts would have to be examined to see whether they can be attributed to be expressive overall. Of course, it is in the nature of any presumption that measured against the concrete case and beyond it, it can prove to be incorrect. In an investigation of individual acts directed towards communication, I think that no automatism can work in favor of any linguistic utterance. If you think about Hugo Bai's sound poems, for example, they make use of linguistic means. It is not immediately obvious whether, and if so, what is to be meant to be communicated with a poem like Caravan. Just as it is not clear whether a hiker who would recite the Declaration of the Rights of Man and of the Citizen in the forest to scare off wild animals is to be granted that this speech performance is to be counted as communication and thus exempt from government regulation or interference. On the other hand, the gesture of a driver who extends his middle finger to another driver who has just parked his vehicle in the space intended for his own, that I think wouldn't require any further explanation. On the one hand, All this, of course, already suggests at this point that just as communication is not to be equated with human language is not necessarily to be regarded as communication. This has quite significant consequences for the present consideration because, as Alexander Michaeljan, among others, has emphasized, speech as a form of human action is subject to regulation in exactly the same sense as walking or lighting a fire or shooting a gun. Um, Instances we may add in which public authorities may well interfere with human action while not engaging in any relevant kind of censorship. Actions may indeed speak. That doesn't make any action speech. After all, the inclusion of an unlimited number of human activities in as communicative that poses challenges of its own. Just as an overly narrow view of protected expression is to be considered inadequate, an overly broad view of what should enjoy the protection of free expression under the title of communication is also far from unproblematic. Even rudimentary knowledge of interpersonal interaction leads to the conclusion drawn in Paul Václavic's meta-communicative axiom that one cannot not communicate. If we were, however, to follow this path, every action that, could consistently be subjected to the protection of free expression, according to clauses such as Article 10 of the ECHR. And this, in turn, would allow this concept to merge directly into an idea of a general freedom of action. If the independence of free expression is to be emphasized, and it needs to be emphasized here because otherwise the nice project pursued by Charles and Pierre would be moot, then boundaries must be drawn that lean towards the, let's say, communicative content of an act without strictly separating speech from conduct in the outset. This, however, also means that the initial question as to the form of action employed must be, I think, redefined, insofar as it must be admitted that it is not the form as such, but the requirements that an act must meet in order to be considered as one of those signs which people use to communicate with one another. And thus, as the exercise of free expression protected by Article 10 ECHR. If, as Christoph Grabenwarter, the current president of the Austrian Constitutional Court, states in his treatise on the ECHR, the protection of freedom of expression ends where it is not a matter of communication, but of mere social interaction. It is necessary to distinguish, I think, between mere expression and communication. And if communication, as summarized by Cass Sunstein, is best understood to include all symbols of expressive meaning, whatever the form of those symbols, then following Ernst Cassirer's treatment of the subject, acts without communicative content must be distinguished from the acts that have, say, symbolic character in that they point beyond the act in question, i.e. that they are not to be understood as self-referential, but are directed towards conveying a content that is not exhausted in the act itself. In the first step, and I know this sounds quite technical, but please, it gets more technical still, but bear with me another 3 minutes, and then we're going to be fine, I promise you. So in the first step, I think if we were to approach this, symbolic acts are characterized by the fact that they can be interpreted separately from the actual phenomenon. So constitutive for a freedom of individual communication is thus, if we were to say, the understanding, overcoming of the immediacy of the factual by way of the symbolic. a process of abstraction, I think, from action to meaning, in which, according to Martin Heidegger, the human being shows itself as being that speaks, as being that is in the way of discovering the world and existence itself. Or to put it in the words of Jürgen Habermas, it is a being that has the capacity to become a naysaying subject in relation to its environment. I do all this name dropping of philosophers here just to impress our friend Charles here, who is, of course, a legal philosopher by trade and has gracefully included a mere dilettante like me in the group of authors he invited to take part of it. A name dropping of philosophers in this context would never be complete if we weren't to mention Aristotle, who has evidently pointed out that man is zoon echon logon. That means an animal that and if we were to translate it literally, and thus contrary to the widespread translation, is not primarily distinguished by its reason, but first and foremost by its language and the power of abstraction inherent to this language capacity. We may sum up to say that man is a rational animal because and insofar as man is a symbolic animal, to whom, in a very fundamental sense, the limits of his language mean the limits of his world. A world that only becomes comprehensible by way of concepts and is thus not only symbolically explicable for the individual, but also symbolically communicable. Language, in this sense, shapes the consciousness of the speaking subjects, and at the same time, what it does is to provide them with a medium for the expression of their own experience. Now, symbolic acts overcome the immediacy of the mere real act by conveying meaning and constitute the act beyond the facticity of the actual phenomenon as a medium. So that is, I think, the first and important, most important maybe takeaway, if we were to distinguish mere expression from communication. Expression that in and by itself constitutes a medium that we may count as part of the large crowd of actions protected according to provisions such as Article 10 ECHR. And within the terrain thus marked out, and I think transcending the boundaries of linguistic and non-linguistic forms of expression, and taking into account what we have already worked out, the functional equivalence between all these approaches, what we now have to do, now we're going, from now on, we're only going downhill. The hardest part is behind us. Is to find criteria that are to be defined on the basis of which it can be determined which acts are to be included as symbolic in this given sense as media in the scope of protection of a safeguard of free expression. However, before we were to do that, there's good news already, because the considerations we have made so far, they allow us to exclude the bombings, to exclude the assassinations, to exclude the self-immolations mentioned before, like other acts of violence, from the concept of communication, as I have tried to outline it here, even if they express a state of mind of the actor. From the very outset, they do not claim symbolic quality that transcends the act in question, but they rather remain attached to the immediacy of the act precisely in their physical reference. Violence, Hannah Arendt taught us this, among other things, itself is incapable of speech. And that is a consideration that we also find in ECTHR case law, at least if we were to apply it mutatis mutandis to a case in which the prison-related prevention of the applicant from performing sexual acts and thereby expressing his affection for other men was not considered a problem to be dealt with under Article 10 ECHR. Article 10 does not encompass any notion of the physical expression of feelings in the sense submitted by the applicant, the court stated. For a long time, however, the question as to whether an act is to be considered communicative in the light of Article 10 ECHR did not emerge with comparable clarity. Rather, the consistently generous case law often contented itself with considering the scope of application to be opened without giving detailed reasons for this. Only recently, a couple of years ago, has the court undertaken a condensation of previously merely implicitly applied maxims into what we may consider an abstract standard. Now, listen closely, because there is that is something few people would only know about the court's case law here, that it actually at one point defined this. In light of its case law, it was the Murat-Vural decision. The court considers that, I may quote here, in deciding whether a certain act or conduct falls within the ambit of Article 10 of the Convention, an assessment must be made of the nature of the act or conduct in question, in particular of its expressive character seen from an objective point of view, as well as of the purpose or the intention of the person performing the act or carrying out the conduct in question. End quote. So now you have to imagine it took a case of a guy who poured paint on Ataturk statues to come up with this. But still, we can be happy to have something to finally work with. Because, of course, the fact that communication must always be based on a corresponding intention on the part of the person from whom it is to emanate has been, say, commonplace of communication theory, at least since the communication model established by H.P. Grice, according to which communication is essentially based on the interplay of the communicative intention of the actor, its disclosure to an addressee, and its recognition by an addressee. Accordingly, it is not surprising that even if the intention of conveying meaning alone cannot be qualified as a sufficient condition for assuming a communicative act, see back violence, it is nevertheless the necessary condition for opening the scope of protection. Or to put it more directly, freedom of speech presupposes a willing speaker. At this point, and this is, of course, also interesting for our problem at hand, another of the aforementioned examples can already be excluded from the consideration to be made in the following, or to be made in my contribution overall. The speech performance of the hiker that roams the woods of Lyon and quotes the Declaration of the Rights of Man and of the Citizen, they are not covered by freedom of expression. From the outset, evidently, they do not make use of the previously assumed basic communicative functionality of human language. They are, if not necessarily self-purposeful, then at least without communicative intention. However, to demand communicative intention as the intention of conveying meaning, this requires more than simply investigating what we may call the mens communicativa of the person who performs the act in question. After all, as already indicated by Grice, this requires not only the assumption of an intentionally acting speaker, but also that of a recipient, at least a potential recipient, towards whom the communicative intention can unfold. Communication thus presupposes both a communicator and a communicee, or as the Austrian Constitutional Court phrased it once, a third party who receives the communicative intent of the conduct in question. For, Fred Schauer taught us this, communication is a joint enterprise, and only that joint enterprise triggers the principle of free speech, which in a dialogical structure presupposes the recipient making use of his or her symbolic capacity, going back to Habermas and the other guys I quoted before, i.e. in an autonomous appreciation of the impression conveyed. Uh, After all, communicative action in this sense is related to the behavior of another and directed toward it in its course. And an act is only an expression in the relevant sense if it is potentially suitable for reaching the other in order to determine him or her in his or her actions. So now that I get it out, and omissions. Now, how the sound poems of someone like Hugo Ball are to be evaluated in this requires further discussion, which must take into account, I think, the requirements of what is conveyed. This initially entails a change of, or necessitates a change of perspective from the previously pursued question of whether a certain act is to be attested something like communicative character to the question of communicative content. So what is communicated in the interplay between communicator and communicatee? The problems here are obvious, and everybody who ever has been in a relationship and said to her partner, "You just don't get me," knows what I'm getting at this very moment. At the one hand, in that such an understanding makes the success of any communicative act, either factually or virtually, dependent on the received content of an utterance. On the other hand, and I'd say building on this, in that subsequently the question has to be answered in the first place as to what degree of clarity and congruence of content is to be regarded as necessary. So, what requirements would a statement have to meet? A newspaper article, one might argue, calling a recently deceased politician a fascist, that conveys a much more precise message than laying a bundle of lictors in front of his grave, which is an act, at least within a certain spectrum, a number of different nuances of meaning can be attributed to. Does that mean, however, that irrespective of the functional equivalence of the forms of expression that I painstakingly carved out before, and contrary to the free choice of means of communication that are expressively affirmed in case law, that the newspaper article does eventually still become the yardstick of the non-verbally communicated counterpart? Hardly, at least in my opinion, because coming back to you just don't get me, even a brief reflection, I think, on how inadequate interpersonal communication is, even when, or maybe even particularly when it makes use of linguistic means, whether conveyed orally or in writing, shows that placing too high demands on the unambiguousness of the message conveyed by an utterance cannot be expedient. The problems with which legal interpretation, and we all know that, is confronted alone, I think, bear eloquent witness to the profundity of the saying that Plato put in the mouth of his Socrates in the Phaedrus, according to which anyone who believes that something clear and reliable will emerge from letters must be highly simple-minded. As lawyers, I think we all can relate to that. If in view of this, one were to demand the greatest possible precision in the sense of an ideal harmony of intention and reception, not only poetry, visual and performing arts would have to be excluded from the outset from a safeguard of free expression. Even the newspaper article, previously cited as a yardstick, would have to fail because of such a claim. For, I think, whatever the author intends to communicate in her speech, it is always possible and indeed highly likely that the ideas the audience receives will be different. Against this background, placing excessive demands on the definiteness of a statement, I think, is ultimately not feasible with regard to any means of expression. A brief glance at the case law of the US Supreme Court may prove useful here. As Justice Souter wrote for a unanimous court in the Hurley case, a narrow, succinctly articulable message is not a condition of constitutional protection, which, if confined to expressions conveying a particularized message, would never reach the unquestionably shielded painting of Jackson Pollock, music of Arnold Schoenberg, or the Jabberwocky verse of Lewis Carroll. In this way, however, the focus is once again directed, I think, to the question of the communicative character of the representative of the respective act, in that the content of a particular utterance in itself may be of lesser importance. Rather, in accordance with the already emphasized pragmatic interpretation of the communicative act, the relationship between the participants in the communication, that is the one thing that needs to be brought to the fore. What is primarily decisive, and this, of course, or at least in my opinion and observation, is something that goes through a whole line of case law with the ECTHR, is no longer specifically what is being communicated, but rather building on an intended conveyance of meaning, irrespective of any vagueness, that what is being communicated is being communicated. Here, I think medium and message merge together in a very fundamental sense. And this in turn makes Kenneth Burke's critique of the phrase "the medium is the message" an essential result of the observations that I just made here over the last 15 minutes. If the medium is the message, obviously the important thing is not what somebody says in a given medium. And now, turning back to Grice, and slowly approaching a conclusion, the focus is on whether a certain behavior is to be interpreted as communicative. A message may be delivered by conduct that is intended to be communicative and that in context would reasonably be understood by the viewer to be communicative, or so we may take from relevant case law. Consistently, however, such a view must also influence the understanding of what I referred to before as inherent symbolism, as it is demanded in ECHR scholarship. Here we have to concede that human activities are too multifaceted for one action or another to be clearly interpreted as communicative without taking into account the context in which it is performed. Take the examples most at hand. Burning a flag, burning a photograph of a head of state. Both actions could easily be seen as a thoughtless form of disposing of household goods that are no longer needed. This example seems rather academic. It is not that academic if you think back for 10 years and take into consideration the Quran burnings by the members of US military at the end of 2011 that were, or so it was reported, unintentionally carried out. And so if we want to go back to some examples from ECTHR case law, such as blocking the driveway, walking slowly on purpose, scaring away fish, etc., etc. The act of a driver who parked his car in such a way that trucks could not access a nearby construction site these acts may well be attributed to the driver's carelessness, or it may be a deliberate act of obstruction in relation to the continuation of the construction work, and thus protected expression for the purposes of Article 10, Section 1 of the ECHR. Just as the flower on the label may indicate the somewhat old-fashioned cavalier or the political agitator. So, still, the assumption of inherent symbolism cannot be understood as an a priori attribution of communicative character, but rather, in accordance with what has been said, only clarify that symbolic acts such as the one mentioned before are determined by the property of functioning, if you will, as a carrier of meaning, transcending the immediacy of the actual phenomenon, as a carrier of meaning, of course, whose symbolic quality is to be considered inherent insofar as it emerges independently without being conditioned by explanatory references. Something that you get, or at least something that you get, is something that is to be got. In order to ensure this, following Grice, one needs to pay close attention to the context in which these processes are embedded. Even more, as the ECTHR in its recent case law emphasizes, the context constitutes the symbol in the perception of the addressee. A symbol can have no meaning apart from its context. After all, communication is a social practice, and it exists within particular social contexts. Thus, however, the function of the context, as the examples already mentioned may have made clear, is consistently not exhausted in the merely affirmative function of being, let's say, the passe-partout of a communicative character of an act that is largely undetermined in terms of content. Rather, and that's something maybe for later, but it's important to emphasize it here, the context-dependent appraisal of an act as communicative necessitates an involuntary approach to its content, insofar as it is often something that cannot be undertaken in isolation from an examination of the concern that is actually pursued by employing a specific symbol in a specific context that constitutes the symbol. Again, as the ECTHR has held, the context of an utterance determines its meaning. The context in which an action is set, if you want to take a very, again, academic example, requires that a hollow hand stretched away from the body not only to be identified overall as an act of communication, but also that it may be interpreted, if you will, in a differentiated way, as it were, as a precondition for such an assessment, as a gesture, for example, of the coach who offers it to the player to congratulate her, as a gesture of the beggar who's asking for money, or as the gesture of somebody who has just stepped outside her house and wants to find out whether it has started to rain. The context is something that allows us to recognize a ready-made in an upturned urinal, and it allows us to recognize a poem, to conclude this also in Hugo Bai's Caravan. So basically, and it only took, close to an hour to do this, there we have it. Liberty that must not be subjected to government license. And the precondition for building a foundation on which the Areopagus can rest. Where do we go from here? That is something I think Charles would ask in this context. And what does the interplay of intent, reception, and context mean for my chapter? First and foremost, it means that the formalities, conditions, restrictions, and penalties employed according to Article 10, Section 2 must be rethought. um, leaving the anecdotal approach that is taken typically in publications such as the guide to Article 10 ECHR behind, condensing it into a coherent framework of legitimate government action vis-à-vis communication, which to regulate is deemed necessary in a democratic society. This, of course, goes hand in hand, or it has to go hand in hand with answering another question. So far, we have dealt with, let's say, structural issues of communication. But does any communicative content so defined actually warrant protection? Does government really need to justify the regulation of blackmail only because the perpetrators engage in communication in order to educate the victims about their demands? Is the law of contracts in and by itself nothing but a giant government interference in the free expression of the parties involved? And finally, at what point is the state required to step in when it comes to communication? And I'm very curious about next week's presentation, because I think this is an aspect that will be addressed there, that far from providing the foundation for the Areopagus, is directed at undermining this very foundations. And how does it work? I'm evidently referring to questions of abuse of freedom of expression here. So you see, there's still quite a bit of ground to be covered. I'd be grateful for any advice on how to approach this. For now, ladies and gentlemen, many thanks for your attention.